There are the regular offenses associated with actually not complying with some aspects of the law, particularly for those folks that have assumed the responsibility for being a substitute decision maker on somebody's behalf, and they deliberately and intentionally don't hold up some of the specified instructions in a PDA. And the most dramatic example that we came up with was if somebody, for religious reasons, had decided and articulated in their PDA, I don't want a blood transfusion. But the person who was appointed as a delegate, they're in hospital, the individual's in crisis, cannot make decisions on their own behalf, says, no, I want that person. I want a blood transfusion for mom. I want whatever. The family members could, knowing all of this, knowing that the client didn't, or the individual didn't want a blood transfusion, the delegate decided against their express wishes to allow for one, they could actually take them to court and have them charged for not upholding a legal agreement. And basically, they're like a contract. Again, there's court powers, and largely those are related to conflict resolution. So if you get to that point where the two daughters, the son and the daughter, or two siblings cannot agree who will represent mom or dad, are just at loggerjams, there are court powers that are at their disposal for resolution. There's also liability protection, of course. There's a good faith clause. So if you proceed, particularly again in an emergency situation, and you do a healthcare procedure that's part of a health catastrophe intervention, I guess, for lack of a better term, and then later it comes to light that there's a personal directive and that person expressly didn't want that treatment, there is a good faith clause that protects the healthcare provider from libelous action. There's also the creation of the personal directive cannot be coerced. This was a really important point for the facilities starting to understand, because as we're going through it and as part of the admission process, they actually have some compulsory aspects like advanced directives that are actually embedded in their admissions process. So we had to talk to them and say, well, an advanced directive is sort of kind of like a personal directive. So if you're saying sign here on the dotted line with these specific areas of decisions, you kind of can't do that after April 1st. So you really need to go back and examine your process and seeing what you're asking these clients and their family members to agree to. And a family member can't create a personal directive on behalf of somebody who can't create it themselves, right? So if the individual doesn't have capacity, then the creation of a personal directive is moot. You would immediately move to the substitute hierarchy, the substitute decision maker hierarchy. In terms of the limitations, of course, like we had mentioned, the personal directive does not permit an illegal act. The appointed substitute decision maker must comply with the requirements, of course, set out in the document. With respect to their roles and responsibilities, again, they felt that this was so important they actually embedded it in the statute as well. The personal directive, again, will not assume or not assure the maker access to services that are beyond the scope of the current program. So for us, when we were delivering this presentation to program staff, the example that we used was that somebody might say in their personal directive, I never want to go into nursing home. Never, ever. Don't ever send me there. I never want to go. But it gets to a point where they've lost capacity, but their care level needs cannot be accommodated in home. And if they don't have the resources to actually pay for 24/7 nursing care to keep them in the home, then and their family members can no longer care for them, then it's appropriate for them to be a candidate for placement in nursing home. So you would have to make that service-specific decision for that, even though he expressly said, I never want to go to nursing home and I want to be cared for in my home until I'm deceased. Again, the personal directives also don't deal with financial management. They just deal with personal health care matters. In terms of some of the benefits, of course, and we had mentioned this earlier, fill long-standing gaps in the current legislation related to consent issues for placement, home care services, and health care outside the hospital. It's going to allow for Nova Scotians to be legally clear about their wishes related to personal care decisions once they no longer have the capacity to do so. Provide clarity for healthcare workers working with delegates or substitute decision makers and their families, and then ensure documented evidence of informed consent. I'm not going to go through this, but it just sort of gives you an idea of, and we inferred this, or I inferred this earlier when we were talking about how we actually delivered some of this training and how many sessions we've actually delivered. Just to give you an idea of the areas of interface or the scope of impact that this act actually has on a number of different areas. So it wasn't I was part of a group, a steering committee that had been working on this for the last 24 months. I haven't been sitting there since '08, but I have been there for quite a while. And around the table, there were 23 of us. There were folks there, mostly internal government folks, but they were Department of Justice, Department of Community Services, Public Trustees Act, or Public Trustee, and there were a number of other Department of Health. And there was a broad representation, but also there was ongoing engagement with these other areas of the healthcare field to actually talk about this particular statute and its possible impacts. So in a nutshell, what does this mean? So it means on or after April 1st, personal directives will be recognized as a legal document and deferred to with respect to all the direction or instructions that are contained within related to personal healthcare decisions. It also means, and this is again a crunchy bit as we're trying to figure this out, what this meant in terms of operationalizing it, informed consent must be formally captured for all clients who have the ability to give that consent. Capacity to consent must be assessed by the healthcare provider, and we have care coordinator in there, is a key element of delivering healthcare services. But we're assuming capacity to consent is always present unless otherwise proven. Again, if capacity to consent is suspect, the legally appropriate substitute decision maker must be engaged and documented to give informed consent for those individuals who cannot consent on their own behalf. So I just quickly wanted to show you a slide of the Public Trustees Office and the new division, just to give you an idea of the delineation between the sections. So there is the public trustee, and she's Estelle Theriault, who kind of sits at the top as the queen bee. But under her, she has these three different areas that have very different focus. And the Healthcare Division's division was created specifically to be a decision maker of last resort related to personal healthcare decisions. So they won't deal with any financial matters. Those referrals will still go to the trust office. And of course, they'll still both get advice from the legal representation. But the financial management piece will still be held by the trust office, and the personal healthcare decisions will be handled by the Healthcare Decisions Division. In terms of their role, and there are things that are embedded with the Act related to the Public Trustees Office. Again, may only act as a statutory decision maker of last resort for incapable persons with respect to those three limited areas that we talked about. So it would be health care, home care, and placement into a long-term care home. That is, the authority is, again, decision specific and doesn't provide the public trustee power to become the guardian of the person, which is kind of an important distinction because there are some jurisdictions that actually have guardianship of the individual, which means not only their healthcare piece and those decisions and related to those areas, but also the financial piece and the management of their estates. If the Healthcare Decisions Division does not handle referrals, again, for financial management, and if these referrals must be made separately. So it's an important point. So even if there was a referral that came into the public trustee in terms of the Healthcare Decisions Division, and there was a financial management piece that was required, that referral to the trust office would have to be separate. So this is the last slide. In terms of resources, there are general information related to the Act and mechanism for developing a personal directive. That's the website that you would go to. They're not there yet. They promise they're going to be there April 1st. So what's going to be posted? What's posted there now is the sort of some high-level questions and answers. But after April 1st, there'll be sample forms of personal directives. There'll be a short form, which actually I just named my husband to make all these decisions on my behalf. And then there'll be a longer form that actually prompts you to go into a little more detail about these different areas of personal health care. There'll also be guidelines. The fact sheet that was copied for you that's here for today is going to be posted there. There'll also be copies of brochures, PDF brochures, that if you wanted to print them off, you could do that. So I want to create a personal directive, what do I do? So there's a brochure that'll have that information in there. There's also will be a brochure so I've agreed to be a substitute decision maker. What does that mean to me? So there'll be a brochure that actually goes into detail a little bit more around that. And then we've listed the Public Trustees Office there as well as a resource, and their forms and all their information related to how you actually make a referral to the Public Trustees Office will be posted to their website. And that's it.
Okay, well, thank you very much, Lorianne, for your presentation today.
No worries. Anytime.